Hello, I'm Dominic. I'm from Bolster Risk Management. I'm here with Steve Graham from McVeagh Flemming, and we're here to talk about shareholder protection and the ramifications that can have for business owners and business value.
I'm a commercial partner and my expertise is in shareholders agreements, and one of the things which I'd like to cover for my clients is to ensure that the insurance services that you provide match up with the documentation which they enter into as shareholders.
So, look, I know, Steve, you've got a couple of key points that tend to come up time and again when you're doing shareholder agreements. Can you talk us through some of those?
Yeah, I think there's a perception perhaps that things like shareholders agreements might be a tick box exercise. So you might see Dom, you might see your accountant, you might see your equivalent of me, and they'll say that it's a good thing for you to have a shareholders agreement, but they won't always say why. And I think one of the downsides that can lead to is an emphasis on what I call a precedent. For those of you who aren't familiar with what I mean by precedent, many of you will be familiar with things like the Auckland District Law Society agreement for when you buy a house. It's a standard form. And I think that leads to situations where people don't always give the thought that they need to things which affect their business and the relationship between them as business owners.
So do you mean that that Auckland Law Society document is effectively like a template? And one size doesn't necessarily always fit all. Is that where you're going?
Yeah, it is. And I think without meaning to disparage my profession too much, I think lawyers have their own versions of the precedents and they don't always understand their client's business. And I think as a consequence, there's a little bit of a failure to give appropriate thought to what makes each business different and what a shareholders agreement should say.
Right, okay. So what are some of the remedies for that situation?
Well, I think the main one is to get a concluded agreement which works for the business. It sounds a bit obvious, and it sounds a little bit like the cure for a hangover is not to drink, but that is what it is. And I think the reality is people need to sit down properly with their advisors and make certain that they're all on the same page.
So to do that, would you suggest some kind of scenario planning, some kind of risk assessments of what certain clauses actually mean, and if that were to happen, how that might impact the business?
Yeah, and it sounds a little bit strange, but it's like everything's obvious with hindsight. And I think one of the weaknesses is that people just don't get down and they don't think about the things which are obvious. Dom, if you and I were in business, for example, the types of scenarios which could happen to us, we might need to know what happens if we need more money. Do we put more money in? If we make money, what do we do with it? My understanding of you is that you're quite hardworking. You might want to reinvest it in the business. I want a boat. So it's those type of scenarios which can happen all the time. And you think that they're obvious when we're talking about them now, but they're not obvious when people go through a standard form document.
Okay. So what you're essentially saying is that these type of typical understandings might seem simple now, but when there's a bit of stress in the system, a bit of pressure, and I want to reinvest in the business and you want to get your boat, and then before you know it, we've got some argy-bargy and we look to the legal agreement to say, can solve this problem, and you're saying the document's not going to stand up to it.
Yeah, so assuming we have one to start with, there is that issue with basically a failure for people to record those key important points and a failure to think about them. And the other, I guess, failure in a shareholders agreement, and it's a bad thing for a lawyer to admit, is those precedent documents, they're full of agreements to agree. So the issue about the dividends, for example, is quite common for a clause to say, we will agree on a dividend policy, but it's great that you want me to pay money to write down in an agreement that you will agree to have a dividend policy.
But if you don't have that dividend policy...
What are you doing if you didn't have that? It's exactly the same situation. So I think that's a weakness that a lot of agreements have. It just leaves too much open and too much by agreement, which is what lawyers are told at law school they shouldn't do.
With some of these things that you've just talked about, what's the impact of it? We can talk about this now, and it sounds like a lot of a headache for a business owner or two shareholders to think about now. But why bother doing it? How's it going to impact them down the line?
Well, I think there's two answers to that. If we move back to one of the issues when people think about this, and it does get hard, one of the other consequences is you don't have an agreement with what people have thought about and have agreed. Those shareholders agreements, they can have unusual provisions. I mean, what's a drag-along clause? What's a tag-along clause? Dom, you're shaking your head like you don't know. I think you probably do. But your clients sometimes don't know, and they sit there and they get hung up on these things. And then basic points about who appoints a director are just not included, and they're sitting in my drawer in this unsigned document. So, consequence. We've all got our war stories, I suppose, but one of my nightmares standard New Zealand company setup, at least in the 80s and 90s. Two groups of people involved, 50-50 shareholders, split between the wife and one person. They have a relationship property argument, and their natural alignment that they thought between a husband and wife on one side, the wife starts voting with the people on the other side, and the person who set that business up, they're marginalised. And yet that particular issue about appointing directors, for example, was obvious to them. Would have been agreed in 5 seconds if they'd sat down and thought about it. A real problem for them later on.
So essentially what you're saying there, Steve, is take the time up front to work through some of the different scenarios and how that might impact the business owners down the track, but spend the time up front to actually get it resolved and sorted and documented.
Yeah, and that's right. And don't treat it as being an impossible task, because we're in business. You would see, Tom, I'm not sure how we're going to resolve that problem with me spending money and you doing all the work to earn it. If we can't, it's a problem. But at least we know that now, and at least we are going to record down the things which we do agree.
Yeah. Insurance component is essentially either a life insurance or a total and permanent disability cover. So if either shareholder is incapacitated or deceased, then at least there's the money set aside in an insurance policy to allow the legal mechanism to then take over. Now this is important because you need to think that let's take a business value, a $5 million business, right? 50-50 shareholding, so one shareholder dies. That means that the other shareholder needs to find $2.5 million to be able to buy out the deceased estate. Now, they may be able to raise those funds privately, mortgage their house or what have you. Chances are, though, they probably won't. The business might have the finance itself. They might have enough in the shareholder current account to pay that $2.5 million. Unlikely. So you need the insurance policy to actually fund that buyout clause. Without it, there are default clauses, presumably in the buy-sell agreement.
Yeah, and if you don't have the buy-sell agreement implemented properly, you can have a difficult situation where the reality of the law is that it is a survivor who is now going to have rights to potentially appoint a director or have some influence in the direction of a business which they have no knowledge in or no skill or expertise in. So I think that is a problem. So you do need to have the agreement put together properly to make sure that is clearly addressed how that works. And I think there's some different mechanisms for that. Definitely when I was a young person, people would just shove a clause in the agreement saying they would take out, so normally life insurance. They hadn't even thought about permanent disability. I mean, who does? And they'll roll with that. But I think as time's proven on, that's proven to be a little bit of a weakness in the structure. And Dom, I'm not sure if you want to go through some of the reasons for that.
Well, I might just pick up on the total and permanent disability part. So again, one of the things we see in agreements is when there's not a clearly defined roles and responsibility for each of the shareholders or each of the directors. So, the scenarios before that, I'm the hard-working one apparently, which is great, and Steve isn't. Now, what happens if I'm permanently disabled and I'm unable to be in the business anymore? Now,
that is my worst nightmare.
That's right. You don't get the vote.
Yeah. So I have to work.
So, does the business carry on paying me? I'm permanently disabled. I can't work in the business, but I'm still I'm still a share owner. So, how long is Steve going to pay me if I can't work in the business? Now, if that's not defined, that's going to cause another set of issues, isn't it?
Yeah, it does. And I think some of those things require a little bit of creative thinking from the people involved at the time. One of the things which might be useful, we've talked about having clear job descriptions, and I think we'd be potentially talking about a different type of insurance cover shortly as well. But for me, in a circumstance where an insurance policy says that Dom is permanently disabled, to me that's almost as good as death. In a situation that I'd rather bring things to a head and say, look, Dom, you can't contribute, at least according to your doctor and insurance people. I think I should use those insurance policies and buy it out now.
Yeah, and that's what they're designed to do. Yeah, perfect. Good. So we've covered some great information here. So if there's any stuff that perhaps you're a bit confused about, or you think, damn, I haven't got that in place, or in fact you want a review of your current document, have a talk to Steve. He's obviously got a wealth of knowledge on how to go through some of that. If you're also thinking, actually I don't have any insurance to back up the legal bit, obviously get in contact with me and I'll see if I can help you. But if we're not your normal lawyer or insurance guy, talk to them. Talk to your current professionals. At the end of the day, what we're trying to get across is you need to have professional advice. It can be a real minefield for business owners to try and navigate this stuff. And if you don't put the right time into it, it can trip you up down the track. We'll see you next time.